Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear argument in 5 cases this morning. 2 are consolidated. The first is 23-493 Werner Enterprises against Blake from Harris County and the 14th Court of Appeals District. Justice Lehrmann is not participating in the decision of that case. The second and third cases are consolidated. 23-568 for Chichi versus Whataburger Restaurants from Bexar County and the 4th Court of Appeals District, and 23-993 Haven at Thorpe Lane versus Pate from Hayes County and the 3rd Court of Appeals District. Fourth case is 23-1028 in the matter of JJT from Harris County and the 1st Court of Appeals District. And finally, 24-616 Butler versus Collins, a certified question from the United States Court of Appeals for the 5th Circuit. The court has allotted 20 minutes for each side in each of the cases, including the 2 that are consolidated together. And we'll take a brief break between the arguments, completing them before we quit for the day. The arguments are being webcast on live this morning and will be available in the archives later today. We're ready for argument in 23-493.
May it please the court. Mr. Wright and Mr. Phillips will present argument for the petitioners. Petitioners have reserved 6 minutes for rebuttal. Mr. Wright will open with the first 14 minutes. Mr. Phillips will present the rebuttal.
Chief Justice Hackton, may it please the court. The Court of Appeals in this case deviated from this court's teaching and from the famous Palsgraf case to find a duty on the driver, Mr. Ali, deviated from this court's holdings in Phillips and in its progeny, including Elephant Insurance and others, to find a new duty on Werner, the trucking company, out of whole cloth, and disregarded all the cases from the Texas state courts and around the country, the lower courts that have adopted the admission rule. And for the first time has held that a driver in his own lane, under control of his vehicle, is liable when somebody on the opposite side of an interstate highway loses control, spins out, crosses over a 30-foot median plus the shoulders, and runs into the driver in his own lane with no time to react. In my time this morning, I'd like to talk, of course, about the duty issues and for both Ali and for Werner, and get to the admission rule if we have time. Of course, there are other issues that we'll rely on the briefs unless the court has questions. So as for Mr. Ali's duty, this court has repeatedly endorsed the limited duty that the Palsgraf holding finds, and that is that you must show a risk to a particular person. This court said as much in many cases since then. It's got to be a person that's in relationship to the actor. And so the duty is a threshold issue, of course, but here the Court of Appeals held that Ali had a duty to everybody, basically. The Court of Appeals misread, we believe, Palsgraf, and Mellon Mortgage says the injured party has to be so situated with the wrongful act that the injury to him or her in this case, or someone similarly situated, might reasonably have been foreseen. And
is it reasonably foreseeable on an icy day that there may be lane intrusion by someone, if not this exact scenario with traveling across a highway median, but just someone skidding and entering your lane?
Well, it's certainly foreseeable somebody in the next lane could come into your lane, but if you cannot realistically travel down the highway in any kind of weather, if you have to anticipate that somebody might, without warning, leave the interstate lane 30 feet across. I mean, that's why they built the interstate highway system, to keep these cars separated, and spin out and come into your lane less than 2 seconds for you to react. Otherwise, you know, and these kind of accidents can happen not just in rain or ice, but the statistics even cited by the plaintiffs, some of those happen on a dry day. A tire can blow out. And so if you have to continually anticipate that, like Justice Posner said, or Judge Posner said in a similar case, if you have to drive so that you have to be able to stop no matter if people are running red lights against the light in your lane, what's the point of having a highway? And similarly here, what's the point of having an interstate? I mean, Ali was driving less than the speed limit. He was under control of his truck. The Court of Appeals assumed all of that and nevertheless found that he had a duty, mostly based on Biggers, this court's decision, you know, some 70 years ago.
Did he owe a legal duty of reasonable care to anybody?
Yes, the people within his, you know, zone, the people that are, you know, I would say within his lane of travel, not just the one lane, the two lanes, the direction of travel.
So anybody that was going the same direction around him, he owed a legal duty to them. And the reason is because it was foreseeable under these circumstances that they might lose control on the ice and slide out into his lane?
Yes.
And why is that any different than it being reasonably foreseeable that somebody on the other side of the interstate could lose control on the ice and slide over into his lane?
For the same reason that it wasn't foreseeable that dropping the package on the train station in the Palsgraf case would injure a lady across the way when some scales fell on her. I mean, it's just you know, there is no way that you can anticipate cars coming across, you know, 30 feet in 2 seconds. Now, if the car had come across a minute before and was stuck in his lane, okay, then he's got time to react and so forth. But here...
Well, that goes to negligence. I mean, that goes to breach of the standard of care. If you have time to react and you don't, then you're not acting reasonably. If you don't have time to react and you don't, then that's not unreasonable conduct. It seems to go to the breach, not to the duty.
Well, this court said in Mellon and in other cases that foreseeability is a part of duty and foreseeability. So we believe that the cleanest way to decide this case is to say he had no duty to people across the road, because where is it going to stop?
Does it matter though? Palsgraf is approximate causation foreseeability case, not a duty case necessarily, but does it really matter which bucket we put it in, duty versus no evidence of proximate causation foreseeability? Do you get to the same place?
Well, we would get to the same place. Jurisprudentially, it might be better for this court to talk about duty, because that's a legal issue that you have to get to first, and that might mean that courts could actually dispose of some of these kinds of cases on summary judgment, rather than saying, well, it's foreseeability, it's proximate cause, and that's a little bit more, some courts might think, of a gray area. But for this case, if there's no foreseeability, we believe there's no duty and no proximate cause. So either way, the court should render judgment in favor of Ali and Werner.
What does the evidence show about the flow of traffic around the truck and the circumstances around him?
The evidence is not, I could not find any clear evidence about how fast other cars were going. There is evidence that at some point 3 or 4 miles earlier, Mr. Ali's truck alerted him to slow down because a car in front of him was going slower than he was, and so he slowed down. But certainly the cars on the other side of the road, including Mr. Salinas, were going at highway speed.
Say that again? They were doing what?
Going at highway speed. Mr. Salinas was going 60 miles an hour on the other side of the freeway.
Is there evidence about the volume of traffic on his side of the road?
Generally, all of the first responders said there was a lot of traffic on the road, a lot of trucks, a lot of cars. There wasn't any kind of scientific, how many per minute, but there were a lot of cars on both sides of Interstate 20 that day.
There are lots of permutations of roads, lots of different kinds of roads. How does your duty argument change if there is no median, so you just have, or maybe a narrower median or no median at all? Then do you expand the class of persons you need to look out for, or how do we craft a rule that covers more than just this particular set of facts?
Well, this particular case, of course, most interstates have a median that's going to be 25 or 30 feet, so that would cover quite a bit of the interstate traffic in the state of Texas. But so to go back to the Balmer case or the Biggers case, either one of them, that was a two-lane highway. And at some points on a two-lane highway, you can get into the other side's lane to pass, depending on the striping. And so you're going to have to anticipate once in a while that somebody's going to be coming head-on at you on a two-lane highway. But here, you know, if I thought that driving down the highway, I had to anticipate somebody would lose control, come across and hit me, and it would be my fault, I might just stay home. You know, I think the rule has got to be drawn somewhere. And yes, I understand, you know, how wide of a median, 2 feet, 5 feet, 10 feet. But I think here, if you say an interstate highway divided by a median of, you know, normal width, 25, 30, 40 feet, I think was actually this one, you do not have to anticipate people are going to come across at any time without warning, giving you 2 seconds to react. And of course, Mr. Ali did have some duty. He had the duty to react reasonably once he perceived the spin out of the Salinas' in that 2 seconds. And the Court of Appeals.
That was a legal duty to Salinas and the Blakes?
It was a legal duty, yes. Once that happened, once they spun out and came into his lane, he had the legal duty, which the Court of Appeals assumed and said that he fulfilled in reacting properly, braking, doing what he could in those 2 seconds that he had. But, you know, I'd like to get to the Werner duties. The Court of Appeals held that Werner, and all trucking companies, by the way, now have a duty in the state of Texas to not prevent a driver from accessing weather information while he is driving. They don't say what device. The evidence in the trial concerned a CB radio. There was evidence, of course, that CB radios have a lot of chatter and it's a distraction or whatever. The most common device that people can look up weather on is a cell phone. Well, the federal regulations prohibit you from using a mobile phone while you're driving an 18-wheeler. And so, but the Court of Appeals says the company cannot prevent the driver from accessing weather information. And they cannot assign an inexperienced driver to what they call a high-pressure delivery. Well, you know, the evidence in the case was this, you know, every trucking company has a schedule. And, you know, this particular load really wasn't due in California for a couple of more days. And of course, Mr. Ali says he didn't even know it was a just-in-time load. But nevertheless, this new duty that the Court of Appeals has imposed, the 2 duties, goes against all this court's teaching in Elephant and HNMC, these cases that we put in our bench book. So that, you know, that can't stand. And this judgment, of course, is based on those duties of Werner and of Ali. And not only that, even the question about Ali's own negligence when compared to Salinas's, that's predicated on a question that asks about Ali's conduct for the entire day, a question we objected to, because they should have asked about his conduct, you know, at the time of the accident, not the entire day, not whether he checked the weather at the last truck stop 2 hours ago, not, you know, whether he wanted his, you know, teacher to be sitting in the cab rather than up in the sleeper berth, how fast he was going 10 miles before this accident. Has nothing to do with the events of this 3-second accident. And of course, that was intentional, the nothing to do part, because as the plaintiff's lawyer said, has been cited in the amicus briefs and in our brief, we wanted to make this case about everything except for the 3-second accident sequence. So it was all about trying the company. And that's what makes these cases so long. That's what makes the discovery so onerous. That's why this case took 6 weeks to try. One of the Wernermen in this case said, to the judge who was conducting the voir dire, why is a car wreck case going to take 4 weeks? That's what the judge told him. It was going to be 4 weeks. And it took 6 weeks. Of course, that person didn't make it on the jury. But nobody should have to spend 6 weeks trying a case about the facts of this accident. It was all about the facts of Werner and their training and their supervision and their policies. And that's why we believe the court ought to adopt the admission rule. And, my time is running short here, but I would commend Justice Wilson's opinion to you from the court below. The admission rule has been accepted and applied in Texas, of course, the Patterson case and many others, and many around the state. We've set out in our brief the sort of count state by state. Some courts, Colorado had it, and then the legislature took it away. But by and large, we think still at least a good half, if not more, of the states apply the admission rule, which would be to say, if you admit respondeat superior, you don't have all of these direct negligence claims because you don't need them. And it just encourages double counting of liability, not only against the company, but it increases the liability and the fault of the driver himself because his driving record comes in when it has nothing to do with the accident in question. Well, I see my time has expired.
Any other questions? Thank you, Mr. Wright. We'll hear from the respondents.
May it please the court, Mr. Walker will present argument for the respondents.
May it please the court. This morning in my argument, I'd like to address 3 matters. First, I will urge the court to overrule Werner's rendition point because Ali's negligence was a proximate cause of the Blake's injuries. Second, I'll discuss how question 1 of the jury charge properly submitted Werner's direct, non-derivative negligence. And finally, I will argue that the court should reject the admission rule because it's contrary to proportionate responsibility. The Court of Appeals spoke with one voice in overruling Werner's rendition point. Werner argues that the Court of Appeals imposed a new duty on the driver of a motor vehicle, but the court did no such thing. Ali's duty was the well-established duty to operate his motor vehicle with reasonable care under all the surrounding circumstances, including road, weather, and traffic conditions, Ali's specialized training and knowledge as a professional truck driver, the size of the 18-wheeler and the risk that it posed, and the foreseeable dangerous conduct of other motorists, whether negligence or not.
Does part of that include a determination to not be on the road at all?
There are
That was
certain...
a big piece of the case, but that seems to be different than operating the vehicle in a reasonably prudent manner. That's sort of not on the road, don't drive.
Well, there are certain circumstances where reasonable care would require the party to desist from driving. For example, if you were in a pea soup fog where you couldn't see past your hood ornament, it would be unreasonably dangerous to continue driving at any speed, so the reasonable thing to do would be to pull over. And Carlos Romay, Werner's vice president of safety, agreed with the Blake's trucking expert on 3 matters. 1, the standard of reasonable care for a truck driver when he encounters icy road conditions is that set forth in the commercial driver's license manual, which is slow to a crawl, 15 miles per hour or less, and cease driving when it is safe to do so. 2, the purpose of this rule is mainly to protect other motorists because passenger vehicles are even more likely than an 18-wheeler to lose control on icy road conditions, and we don't want an 18-wheeler going highway speeds on icy roads when another motorist loses control in front of it. And 3, no one should drive on ice, and if the road was icy, Ali should not have been driving. Those are all admissions that Werner's own safety manager admitted at trial. Werner's proposed duty rule that a motorist never, under any circumstances, owes a duty to motorists on the other side of a divided highway is too inflexible because it does not account for the innumerable combinations of circumstances that we encounter on our highways. Werner has cited...
What does the record show about the traffic around the truck and the volume of traffic, the speed of traffic on his side of the road?
I appreciate you asking me that question because I wanted to address it. So the testimony was that traffic was fairly heavy on the eastbound lanes, the lanes that Salinas was traveling. And Ali testified that there was no one around him at the time. However, witnesses testified that there was a black SUV that was just in front of Ali that moved over to the right as the Salinas pickup crossed through the median. The engine control data information from Ali's truck shows that he was traveling between 60 and 65 miles an hour in the several minutes approaching the site of the collision. Then
And just ahead of it, it was more like 50, right?
he slowed down.
Yeah, so we're talking ahead of the collision, he slowed down to,
He slowed down to about 45 and then speeded up and was at 100% throttle and was going 50.5 miles per hour at the time he began to brake. So the inference is that he was going 60 miles an hour, the SUV was going 45 miles an hour, so Ali slowed down to 45 until the SUV pulled out of the way, and then Ali was speeding back up, and then he saw the pickup truck enter the median and hit his brakes. So the question was, what does the evidence show about traffic conditions and speed and so forth? And that's what the evidence shows.
And that Salinas' speed was 60 when he lost control?
Yes, he testified that he was traveling about the same speed as the other cars going that direction. And there's a reason why.
Which was fairly high traffic heading in eastbound direction.
Eastbound. And there's a reason why that traffic was going faster. The weather system was basically, the way the weather system was located geographically, the Salinas vehicle had only entered winter weather about 5 minutes before the collision. So while Ali had been traveling through winter weather for at least an hour, Salinas had just encountered winter weather, and the same with all the other drivers. And so that could be an explanation for why traffic was moving faster on the eastbound lanes at that location than it should have been traveling on the westbound lanes. Now, I said Werner's rule is too inflexible, but that doesn't mean that there is not a way for the court to limit the scope of liability for a driver without adopting the inflexible rule that Werner proposes, and that is to simply allow the jury to determine breach and proximate cause, and that finding is subject to appellate review for legal and factual sufficiency. That way, the courts of appeals can exonerate a driver when the injury was not a foreseeable result of the driver's negligence, and yet give the courts the flexibility to hold drivers to reasonable care when the circumstances require it.
My question is, why do you succeed even under that standard, given the width of the median and just everybody's common experience of driving, which is it does not take into account typically the extraordinarily unusual circumstance of somebody spinning across a median of that width.
But in this particular case, with these unusual traffic and weather conditions, remember, the road was like a skating rink. It was covered in ice. Cars were going off the road left and right. There were even 2 prior cross-median collisions in this case. And the testimony, remember, was that the very reason we have this rule for truck drivers is because it's foreseeable. that passenger vehicles will lose control on ice.
Was there evidence that the driver had seen other cars spinning across the median?
So the driver no, there was not evidence that Ali was actually witnessed a cross-median collision. What there was evidence of was that he passed crashes that were the result of a cross-median collision, and there were cars off the side of the road and so forth.
Was the median iced over?
Well, actually, there was testimony that when one of the witnesses walked on the grass, it was crunchy, like it was ice. And remember,
But you would think you'd still get better traction on that than you would on a frozen road.
fair enough, but remember, this was a 42-foot median, which is about half the length of the 18-wheeler. I mean, that's not a very wide space for a car that has lost control on ice to traverse. And there was no median barrier, there was no guardrail, there was nothing to impede cars from crossing through the median. In fact, in addition to the two cross-median collisions, there was a third collision where a car would have gone into the median, but at that location, it hit a median barrier. That's why we have median barriers, is because cross-median collisions are foreseeable. In some cases, there may be some circumstances where, as a matter of law, a cross-median collision is not foreseeable and a driver doesn't have to take any precautions against it. But in this case, the evidence was clear that a cross-median collision was foreseeable. And remember, foreseeability does not require the exact sequence of events to be foreseeable. It just has to require that a similar event might occur. And cars were sliding all around. It's been admitted that it was foreseeable that a car might lose control on the westbound lanes and slide in front of the 18-wheeler. The jury found that it was foreseeable that a collision like this would occur, and that finding was well supported by the evidence. I want to briefly address proximate cause. In this case, both accident reconstructionists, Werner's and the plaintiffs, testified that if Ali had been going 15 miles an hour at the time and place that he began to brake in response to the Salinas vehicle entering the median, he would have brought his 18-wheeler to a stop before it collided with the Salinas pickup truck.
Of course, that's always true. Right? I mean, if the speed limit on I-35 was 15 miles an hour, there wouldn't be any wrecks. I mean,
Well, it's not necessarily always true. For example, the difference between when excessive speed is a proximate cause and when excessive speed is a mere condition has to do with whether the driver could have avoided the collision if he had been going a reasonable speed at the time and place that he should have reacted to the impending collision. The Washington courts
so
decided...
that goes to my earlier question about the traffic conditions and the idea that the only reasonable speed under these circumstances is 15 miles an hour. Is it your position that that's just established and you can sort of take that for granted?
Well, yes, the evidence in the case was that an 18-wheeler driver should drive 15 miles per hour or less on ice. And in fact, in our brief, we talked about some of the other people who drove on ice and explained that they were all driving around 15, 20 miles an hour, even those who were not 18-wheeler drivers. And so it was far too fast to be driving 50 miles an hour on ice. And in this case, Andy Irwin, the accident reconstructionist for Werner, testified, and I quote, "I think we can agree that we won't have this crash at 15. If Mr. Ali is in the same location he was when he reacted, then he's going to come to a stop before the crash happens. That part is always true." And later he said that's a mathematical fact.
So if that covers but for causation, but for the fact that he was going at that speed, he wouldn't have been in the location where it crossed paths with the car coming across. But what about substantial factor causation? Doesn't that just furnish the condition that makes the injuries possible?
No, Your Honor. The way that courts distinguish between a cause and a condition in these excessive speed cases is they ask the question, would the wreck have occurred if he was going a reasonable speed at that point of notice, at the point where he should have begun reacting? If he could have avoided the collision by taking evasive action, had he been going a reasonable speed, then his excessive speed is a substantial factor. That's like the Biggers case or the Lofton case that we've cited. On the other hand, if he would have been unable to avoid the collision, even if he was going a reasonable speed at that point of notice, then his excessive speed was a mere condition that made the wreck possible. It just merely put him at the wrong place at the wrong time. But in this case, because Ali could have avoided the collision had he been going a reasonable speed at that point of notice, his speed was a proximate cause.
So for purposes of duty, not breach or causation, but duty, if the weather had been fine and Salinas had been going, say the speed limit, is it 65 there or 70? I can't remember, but.
I can't recall.
Let's say
It
it's
may have been
65.
75 even.
Okay, I can't remember how far outside of Odessa it was, but let's say it was 65. And Salinas is going 65.
Right.
But has a blowout, left front blowout, sends him off into the.
Right.
Truck's coming the other way with Ali driving, and he's going 75, 10 miles over the speed limit.
Right.
For purposes of duty analysis, is that any different than the circumstances here? Is there, in terms of the legal duty to the driver who unexpectedly comes across, to be driving at a speed that's a reasonable speed, which arguably 10 miles over the speed limit would not be?
Right. Well, so I don't think it would change the duty analysis because if you're going too fast to properly react to someone who comes into your lane for whatever reason, then you've still violated your duty to exercise reasonable care to other motorists. Now, it's possible that a court of appeals might say that was unforeseeable as a matter of law, and therefore there's no proximate cause. But I think with the various circumstances that we have on our highways, it makes more sense to cabin liability through proximate cause and legal sufficiency review rather than setting out a rigid no duty rule for people on the other side of the highway. I have limited time left, so I'd like to switch gears now to the admission rule. This court should reject Werner's invitation to adopt the immunity rule that they call the admission rule for 3 reasons. Number 1, it violates Chapter 33. Number 2, it results in a distorted apportionment based on a fictional view of the facts. And number 3, it disincentivizes employers from training and supervising their employees. First,
Why isn't the idea of direct liability just redundant of respondeat superior liability? We have one actor on the road that day. There can be all kinds of evidence that informs whether that actor acted reasonably under the circumstances, including the amount of training, all the circumstances. But yet the jury is told to consider that actor separately and independently from the company who has assumed the liability of the actor.
Because the reason it's not redundant is because vicarious liability, you have one bad actor, one person violated a duty, and we're imputing his liability to a faultless master simply because of the relationship. But in derivative liability, like negligent training and supervision, both the negligence of the employer and the negligence of the employee contribute to the injury.
But negligent training is an exception to the general rule that a corporation acts through its employees, and it's the employee that is submitted, not the employee, and then a bunch of other people associated with the company. It's either together, the employee and the company or the employee, but it's not separate blanks for each.
Well, but I would argue that Chapter 33 requires the jury to apportion responsibility between all defendants, responsible third parties, et cetera, whose breach of duty in any way contributes to the harm. And when...
So if you had a large, say, refinery blowout that caused injury, and there were 100 or 150 employees that informed the bad decision that led to the blowout, would a jury then be asked to find liability for each individual associated with the company?
I see what you're saying now. No, that's not what I'm saying.
Okay,
But
so how do we differentiate what was here seemingly like company decision-making that informed the liability of the truck driver, as opposed to this idea that each individual person at a company is a separate piece of liability that ought to be submitted to the jury?
So the company has a duty to train and supervise its employees. If it breaches that duty, and as a foreseeable result of that breach, its untrained employee causes injury, the company, by that breach of duty, has contributed to the harm. It is unfair to hide that from the jury. My time is up. May I finish?
You may finish.
It's unfair to hide that from the jury and then foist liability that would ordinarily fall on the employer onto the untrained employee.
Any other questions? Thank you, Mr. Walker. Mr. Phillips, you have 6 minutes.
Thank you. May it please this honorable court. The Texas Supreme Court has addressed most negligence cases in this century by looking first at duty. And under Paul's graph, the duty here is clear. It's to those within the range of apprehension. Tab 1 of our bench book tries to go through every case that has involved a cross-median accident that's been reported, trial or appellate, in the United States. And none of those cases have held the driver who has stayed in his or her correct lane liable to someone who has crossed the median unless that initial driver committed some negligence after the risk was perceived. So if Ali had not applied his brakes, if he too had gone into a skid and had crashed into the car being driven by Mr. Salinas, he had a duty at that point. But no case has held.
Your co-counsel, I think, in his presentation conceded that had the automobile crossed the median far enough ahead of Ali's truck, Ali would have owed a duty to the people in that automobile. Do you agree?
Absolutely.
You agree? So it's just a question of how much response time the truck driver had in terms of determining whether there was a legal duty.
Well,
it's not
yes.
the fact that they're coming across a median. It's how much response time they had.
Well, it is that they're coming across the median because you owe a duty to somebody that is in your lane of travel on a divided highway.
Well, this
And
car
if a
was
person,
in his lane
he
of
gets
travel when he
in
hit
that-
him.
That's correct, but not in time for him to do
So
anything.
it goes to response time,
Yes.
not to crossing the median.
Well,
In terms of whether there is a legal duty,
yes, there is not a duty to someone on the other side of a divided highway. There is a duty to someone on your side of the highway. If you then are negligent after that duty arises, then that case can go to a jury and they can weigh it and you can look at whether or not there's proximate cause. But this case, as my co-counsel says, should be resolved on duty because that's easier for courts to weed out which cases may possibly have a chance of success after a lengthy trial and which ones don't.
But you've just both agreed that there is a duty. It's just that your position is that the duty is narrower than the one that they posit and that it wasn't breached.
Yes, the Blakes
So we can't-
essentially, when it all breaks down, want any driver to have a duty to the world, which was basically Judge Andrews' dissent in the Palsgraf case. And this court has consistently rejected that. Now, you can reach the same result in this case by assuming a duty and then looking at whether or not there's proximate cause in fact or proximate cause. And we do that in our brief at some length. It gets you to the same place. We think duty is the cleaner way to go. And we do think the opinion below is unique in American jurisprudence, as would this court then ratify that unique opinion if it were to affirm this judgment as to Ali. I want to talk for a minute about Werner's liability, because it is every one of the many claims that the plaintiffs make about Werner is something that would not have happened had Ali not been on the road and done what he did. So if Ali's not negligent under the Endeavor insurance case, under many Endeavor Resources, I think, and many other cases of this court, if Ali was not negligent, Werner cannot be negligent for the claims made here. It's not as if Werner put Ali in a dangerous truck that exploded or the trailer came off while driving. These are all derivative claims against Werner. And the Court of Appeals could not have affirmed this judgment against Werner because it only found two duties on Werner, two unique duties, never been found before by any other court. But it ignored all the rest and said there was a Castile waiver. Because the word Castile was only mentioned 15 times in the objections that were lodged to the charge, that was not enough to put the judge, a judge who said, hey, I told you guys there were problems with this charge, did not put the judge on notice of any problem between asking the jury about what might be a derivative duty and what might be a duty that had just been invented in this case, like the duty to hire somebody as a safety director who's tough enough to stand up to the management side, and several other unique duties. They're laid out in the brief, a lengthy list. So we do think the admission rule should be adopted in this case, although it is not necessary to do so in order to reach a judgment here that would reverse the judgment against both Ali and Werner and render judgment that the plaintiffs take nothing.
Any other questions? Thank you, Mr. Phillips. The case is submitted, and the court will take a brief recess.
All rise.